It's a form of Likee TV and so Mr. Sen and number channel and so on hit at my subscribers and mean dropping your latest news content over the brain on so inside and be at me at ye na ye borrow in Simnema reporter yensa air canning in a NPP candidate in the Omo voice out in this Omuko independent candidate Kofa Honsen Simina and Bayano reported in the speaker and still now or stand there is or busy on the stand you really know make it as the independent candidate our friend people is only they have no business in parliament be only business in parliament be na yemum inji nseme bande kan ho no yede mu nseme bebrem.
Oh, sorry, your microphone is off. Please put it on. Yes.
My learned friend and senior is simply saying that, you recall when he appeared before the court to move his the application to stay the orders given by the Supreme Court.
Yes.
The court kept repeating that if the Supreme Court give orders and you fail to comply, it's grounds for removal.
Yes.
And if you look at our constitutional provision, Article 2.
Okay.
Article 1(2) specifically says that where an act or an omission on the part of someone is declared as unconstitutional,
okay,
to the extent of that inconsistency with the Constitution, it will be void.
Right.
Article 2 gives the power, and that's the authority upon which Afenyomakin went to the Supreme Court to challenge the Speaker's decisions which happened after the fact.
Okay.
Now, when that happened, the expectation is that after the Supreme Court has given its decision declaring the act of the Speaker to be unconstitutional, the court will go further to issue specific orders directed at the Speaker. Let's say an order directed at the Speaker of Parliament to allow the NPP to sit on the right if that is the majority side, or to sit on the left if that's the majority side.
Okay.
Or an order directed at the Speaker to enforce the judgment of the court, which is that to allow to say that his earlier decision, or to allow those persons into the presence of Parliament.
Okay.
Whichever order the court was supposed to give effect
to
the declaration of unconstitutionality it has made.
Okay.
But when you look at the decision, no such orders were given.
Okay.
So effectively, there is nothing, aside the fact that the Speaker is only mandated to accept that the court has declared his decision to be unconstitutional.
Okay.
There is nothing more on his part he's supposed to do.
Right.
In respect of being a direct order directed at him, the Speaker. So if there is no order directed at me to comply with, then the question will arise whether Article 2, when you see Article 2, 3, 4, all talks about the punishments you are likely to suffer upon failure to comply with an order, not the declaration made. And the orders are supposed to give effect to the declarations made by the Supreme Court.
I see.
So as it stands now, there is nothing to give effect to the declaration that the Supreme Court has made so far.
Okay.
And if the Speaker just merely recognizes the decision, but does not take any particular step to enforce it, you cannot now come under Article 2, 3, 4, and the rest to seek to penalize him.
Oh, really?
Because there were no specific orders directed at him.
Okay.
For which he may have failed to comply, and then punishment arises.
Right.
Because it's grounds for his removal as Speaker.
Right.
It's contempt among so many things.
Right.
So that is why my learned friend and senior took pains to explain to the public why that omission or failure on the part of the Supreme Court is important. Because then now nobody can go and strangle the Speaker for failing to comply with orders of the Supreme Court.
Okay.
The Supreme Court has not given such orders.
Okay.
So simply put, that's what he's saying, that there is nothing for the Speaker to comply with. The decision made by the Supreme Court is applicable to all of us.
So hold on. Does this mean that Speaker Babin can decide to disobey what the court has said?
Effectively, there is nothing to disobey. There's no order to disobey, so to speak. The court has said that your interpretation of the Constitution, that the seats are vacant, is wrong.
Okay. That
interpretation is unconstitutional. So in effect, the seats are not vacant. So we all agree, as students of constitutional law, that to the extent of that inconsistency, the decision of the Speaker is void. Now the question is, the Supreme Court was required to go a step further because the Speaker made, I have not followed the parliamentary proceedings, but I believe he went further to make orders pursuant to his interpretation or his understanding of the Constitution. If the court did not go further to set aside those orders and direct the Speaker or whoever is in Parliament who needs to be directed to take a particular step, then it will be very difficult for Honorable Afenyomakin to go throwing the decision at the Speaker or Deputy Speaker or Honorable Atuforsen or anybody for that matter saying that the court said you should do the court has not said what should be done.
Right.
The court just said what you did is wrong. But the court did not say what should be done going forward.
I see.
So in that situation,
okay,
you cannot hold back.
So essentially what you're saying is that it is trite law that declaratory orders are not enforceable.
Generally, declarations are not enforceable. And let me take you back to a bit of history. And my senior here may have been around at the time.
Right.
You recall there's a popular case which all constitutional students are referred to read. Salah versus Attorney General.
Okay.
When that decision was given, when the then Prime Minister sacked some public service workers, about 400 and something.
To be telling Parliament what to do.
Well,
could that be the reason?
Yes, I was not on the panel, so I can.
Right. No, not the Salah case, but I mean, I'm talking about this particular one here.
I was not on the panel, so I don't want to speak for the panel and why they failed.
Right. No, I was trying to see if you could have that again.
It could be the case that they don't want to direct the speaker because already the mood of the country said that people are beginning to think there's a tussle between the judiciary and the legislative arm of government.
But hold on, Randolph. Isn't it implicit? What is the issue? What is the matter in issue? Speaker says, per my reading of the law, these guys have no business being in Parliament. Supreme Court says, well, that is not the understanding we have. The understanding we have is that the guys have a business being in Parliament. So do I need to tell you that allow them to be in Parliament?
You don't necessarily need to tell me that you have to come to Parliament or not. But you see, if you look at our constitutional provision, and every lawyer will tell you that declarations in themselves, like you said, are not enforceable. Generally. They are not enforceable.
Right.
So the court must now give a further order to enforce. And the Constitution is the document that says that for the purpose of giving effect to the declarations made by the Supreme Court, further orders must be given.
Okay.
Otherwise, there will be no need to give effect to it. For the purpose of giving effect.
It may order.
So that's if the court wants effect to be given to the orders so made.
That's fine. That's fine. I think we can move on. So, Randolph, what do you make of this judgment? And, there's four of us, so we'll go around the table. But which aspect of this judgment do you find either interesting, controversial, whatever it is? But which aspect of this judgment would you want to look at whilst I go around the table and get Mr. Ansari and the rest to also give us to share their perspective? Now, I'll come back to you. Which aspect do you want to look at?
I want to believe this is just an introduction.
Yeah, this is an introduction, yes.
Now,
but good judgment? Sound in law from where you sit?
Oh, I mean, if depending on the philosophical school you want to belong to, we say it is sound.
Right.
But technically speaking, and practically speaking, I think this judgment does not do justice.
It's problematic.
To the issue at hand.
Okay.
Because, he's an academic. He may describe it as an academic exercise because how to practicalize it now becomes a problem.
Right.
In terms of the political parties and how they go about their politics.
Right.
It's very difficult to practicalize this particular decision of the court. That's why I say that its implementation vis-a-vis parliament and political parties will become a problem.
Okay.
So that and that is what leads me to the conclusion that I think that the actual issue that was sent to the court
has not been addressed.
Has not been addressed.
Tell me why.
One. Now, if Afenyomakin, the Honorable Afenyomakin, was the one who took the matter to the Supreme Court.
Absolutely.
Now, if you look at page 83 of his own arguments he made in the Supreme Court.
Okay.
His arguments. And if I may just refer to that particular portion.
Okay.
Page 83. And His Lordship Justice Tanko just quoted that submission made by Honorable Afenyomakin.
Right.
And this is what he said. The plaintiff submitted that the operative phrase in Article 97 is to leave. So the court was called upon to determine whether these people, as the four affected persons, had actually left their political status in which they came to, or the vehicles through which they came to Parliament. And that any member of Parliament can be deemed to have left the party or changed his political status based on his own conduct. Based on this proposition, counsel for plaintiff, which is Honorable Joe, that even took Honorable Afenyomakin to court.
To court, okay.
And his argument was that look at the conduct of the person to determine whether reasonably we can say they've left their parties.
Or not.
Let me ask the co-panelist here. Reasonably, can we say that Honorable Morrison is a member of the MPP as of today? Reasonably, can we say that Amenfi Central MP is a member of NDC as of today? Reasonably, can we say, based on the facts, that the other four members of the two affected are members of their respective parties, through which they came to parliament as of today. So if the question is no, then the answer given to us by the court is wrong. Because reasonably, they don't belong to that vehicle anymore. But the court took the view that in determining whether they have left or not, you have to look at prospective. That's the next parliament. I take a different view because parliament is a continuum. We have sessions of parliament. Every session of parliament ends after 4 years.
Yes.
So that session of parliament will end, is it 7th January? Will end.
Okay.
Now today, as we speak, the fundamental question we need to ask ourselves is, these 4 people, are they, in what capacity are they members of parliament? The court has said what it has to say. But practically, in what capacity are those persons in parliament?
Okay.
Is Honorable Esiama, the one who went independent?
Andrew Amwakwe Esiama.
Is he still an independent candidate or a member of the MPP? Because, and that even leads to the question. If you look at the MPP's constitution, look at the NDC's constitution, it is practically impossible for one to become a parliamentary candidate of those parties without being members of the party. So how is it possible for Honorable Esiama to become a parliamentary candidate for MPP when he's not a member of the MPP? How is it possible? I've forgotten the name of that Memphis Central man.
Oh, yeah, what was the name? Peter Kwachi.
Who came to parliament through the vehicle of NDC, filing independent now. Which vehicle is he going now? He's not, as it stands today, we speak. They are not members of those political parties anymore. They are not. And
by the operations of their own political party's constitution.
By their political party's constitution and their own conduct, telling the whole world.
Okay.
And I'm borrowing the words of his Honorable Afenyo Market.
Okay.
Telling the whole world that they have left their political parties.
Right.
And the constitutional provision we are dealing with is very simple. It says that when you leave your party, the party through which you came to parliament, and you seek to remain in parliament has not ended. So as we speak, the people are still in parliament. They are still in parliament.
Yes.
But can we say that they have not left their parties? That is a fundamental question. Can we say that they have not left their parties? They are still in parliament.
So essentially what you're saying is not a matter of law, it's a matter of fact that they've left.
It's a fact that they have left. And you see, when you go to Article 97.2,
yes,
it carries a very instructive provision. His Lordship Justice Dakun made reference to it. His Lordship Justice Asidi made reference to it. 97.2 says that, and the court made reference to it to justify why the constitutional provision does not prohibit all forms of alliances or whatever.
Right.
But you see, if you look at that constitutional provision carefully, you will see that it says that alliances or mergers sanctioned by that party's constitution.
Okay.
Which means in determining some facts, you have to go back to the party's constitution, which the court in this case did not even do at all. They did not even consider the party's constitution to check whether those persons are still members of the parties, through which they became members of parliament. We are looking at present, and how does what they have done affect the present?
Okay.
And from my position, how it affects the present is that they are no longer members of their respective parties.
Right.
Period.
Right.
No other argument or submissions can change the fact that they are no longer members, which means the first provision of the constitution, the first condition, that is leaving your party under Article 97, have been satisfied.
Okay.
So they have left their parties.
Right.
Or the vehicle through which they came to parliament,
So
they've left it.
so I think your point is that you are surprised that for a matter which is unambiguous, right?
In fact, there is
there's no ambiguity. So you're surprised that the court is litigating over this and actually insisting that they are still members of parliament.
You see, I side 100% with the decision and the reasoning of the former speaker,
Speaker
Michael Quay, on a similar fact that affected, I think, the same Esiama in this matter. Because if you apply the purposive interpretation, and you arrive at the conclusion that the Supreme Court arrived in this present case, effectively what you have done is that you have created a situation where persons can rely on the resources of political parties, enter parliament, then subsequently go to town and say that I am no longer willing to do business with you, and that going forward, I am going to do business in A, B, C, D manner, and whatever it is, and fall short of just saying I've left your party and still be in parliament, and the party cannot do anything about you.
Okay.
That's it. And there's one thing that I also need to bring.
Just briefly, quickly, before I go around the table.
The court kept making reference to the fact that filing of the nominations by the said persons is merely a declaration of intention. I perpetually disagree. Because if you take if you look at the historical facts before us, in, I think, the years 2000, 2003,
Okay.
there is a case, New Patriotic Party versus National Democratic Congress,
Right.
where a person went to town posting posters. He was a member of, I think, the NDC, wanted to contest on the MPP's ticket.
Right.
He went to town publishing posters all over town, clearly showing that in the coming election, I'm going to contest on the ticket of MPP or NDC.
Right.
The matter went to court. The Supreme Court took the view that when we talk of an act under Article 2 of the Constitution, we are talking about an act within the meaning of a public law, and that political party elections are only private. So we cannot say that, properly speaking, the person has taken a step. But if the person goes further to file nominations with the Electoral Commission, then an act would have occurred. In this case, these people have gone further to file nominations with the Electoral Commission. So what further act or what further conduct on their part are we looking for to show that presently they are no longer members of their parties?
I see.
There can be no better declaration of acts or conduct than this.
Okay. Mr. Sassari, I do not hasten to proclaim that I have apprehended with despair the majority's conclusion in this suit, but I state with utmost deference to the honor.
Edomasi Samuel Brewer Daily Update TV.